first chair for today is Mr. Deepak Raju. He's the Senior Associate for Global Arbitration, Trade and Advocacy at Sidley Austin in Geneva. Mr. Deepak has also worked previously in Mumbai in one of the largest law firms in India and has worked on various aspects and dealt with various clients in terms of financial market regulations. He's also worked as an intern in the WTO, in the Appellate Body of the WTO. His area of expertise is international trade dispute, investment arbitration, and public international law. He counsels sovereigns and corporations in matters that are related to state-to-state disputes, investor-state disputes, and other disputes where one or more sovereigns are involved. And in the context of his engagements, he's counseled a variety of clients in varied areas, such as agriculture, aviation, steel, sports, and media. Mr. Deepak also teaches a course on settlement of international disputes at the National University of Juridical Sciences, Kolkata. I welcome you here today, sir, and I would request you to please address the gathering.
Thank you. First of all, thank you, organizers, for inviting me to this event and for giving me this opportunity to share a few thoughts. So my own topic is litigating the security exception, lessons from recent WTO disputes. So as it was mentioned in my introduction, I'm a practitioner, I'm a litigator, and in the recent times, I've had the opportunity to work on certain disputes which involve the security exception. So my perspective on this is a little bit of a practitioner's perspective, not particularly academic. So I hope my academic colleagues in the audience will forgive any shortcomings resulting from this not being deeply academic. Now, I suspect most of you in the audience already have quite a bit of a background to international trade law and know what the security exceptions are about, but I'll introduce the exceptions for those who are not familiar with it briefly, and then we'll look at some of the recent cases in which these exceptions have been litigated. And finally, I will propose a few lessons that litigants can learn from this case law. So first, what is the security exception? So as you are all aware, WTO agreements, WTO obligations are set out in a number of covered agreements. And three of those agreements, the three most important agreements, have provisions which are in the nature of exceptions and are titled security exceptions. There is Article 21 of the GATT, Article 14 bis of the GATTs, and Article 73 of the TRIPS agreement. Now, what it says is, in certain circumstances, and I'll come to what the circumstances are, the provisions of the agreement shall not prevent members from taking any action which they consider necessary for the protection of their essential security interests. So that is the chapeau to each of these provisions. Article 21 begins with these words. And then there are three subparagraphs. The subparagraphs speak of relating to a fissionable material, relating to traffic in arms and ammunition, or keeping a military establishment supplied, or in time of war or other emergency in international relations. Now, while this language originally appeared in GATT 1947, and therefore it has existed on the text for over 70 years, this provision was generally not litigated for a long period of time. And that was in part because there was a view among certain WTO members that this provision is self-judging in nature. What does self-judging mean? Some members were of the view that if a complainant brings a case and the respondent says, we acted according to the security exception, that automatically won the case for the respondent. That means when the respondent says we acted according to the security exception, the panel could not look beyond that assertion, could not look at whether or not that assertion was true or justified, and that would bring an end to the case in favor of the respondent. So this was one view, and this view may have prevented members from bringing cases where they thought the respondent was likely to assert the security exception. Now, after a long period of no cases under this provision, in the last few years, suddenly we've seen a number of disputes being brought where the respondent asserts security exception and the complainant continues in its efforts to win the case. So you have panels actually being called upon to adjudicate what the security exception means and how it applies in a specific case. The first panel to interpret the security exception, and here is where we turn to the discussion on case law. The first panel to examine the security exception was a panel in Russia Traffic in Transit, DS 512. And that panel was dealing with certain transit restrictions, border measures imposed by Russia. And the context to those measures was the conflict arising out of the Crimea situation. So Russia imposed certain measures, and those measures prevented the movement of goods between Ukraine and Russia, or from Ukraine through Russia into other countries. So Ukraine brought a case against Russia, and Russia claimed the security exception. And the panel, in examining the security exception, said that the defense is not self-judging. The three circumstances under the sub-paragraphs to Article 21 of the GATT, that is fissionable material, traffic in arms and ammunitions, or keeping a military establishment supplied, and war or other emergency in international relations, the panel said these are objective facts amenable to an objective assessment by the panel. So the panel had to decide for itself based on evidence, as it does with respect to any other factual proposition, whether or not one of these circumstances existed. Now, in that case, the assertion was that there was an emergency in international relations. And the panel actually interpreted that term and said an emergency in international relations is not a mere political or economic disagreement. It is a serious matter. And the panel says it is something like military conflict, latent military conflict, a heightened state of tension engulfing or surrounding a state. So this is a very serious matter. And on the facts, the panel had to find whether or not an emergency in international relations existed. In that case, the panel found that an emergency in international relations did in fact exist. Now, even if you have an emergency in international relations, what that allows a member to do is take any action that it considers necessary for the protection of its essential security interests. Now, that part, that is the chapeau, we are going back to the chapeau. In the chapeau, the words "it considers necessary" was what is used by a number of commentators and a number of members to argue that the defense is self-judging. But the panel said that there is still a test of good faith. So even after objectively establishing that an emergency in international relations exists, there is still a test of good faith. And that test of good faith is, one, the respondent has to articulate an essential security interest. It can choose its own essential security interests, but it cannot guise trade interests or commercial interests as essential security interests. So it has to articulate an essential security interest. And second, it has to provide a plausible explanation as to the connection between the measures that it has taken and how they protect the essential security interest from the threat that is created by the war or other emergency in international relations. So while on the chapeau that is considers necessary to protect its essential security interests, while there is an amount of deference, and this is not the full-scale de novo objective assessment by a panel that we usually see on other fronts, there are still disciplines imposed in the interpretation of that term. So overall, what this meant is that a respondent does not get a free pass simply by referring to Article 21. There are elements to substantiate. And the panel in Russia Traffic in Transit identified some of those elements. Now, a second case where a WTO panel had the occasion to examine the security exception arose under Article 73 of the TRIPS agreement. And this is a case that my team litigated. I was part of that team litigating this case for the complainant. So this is Saudi Arabia protection of IPRs. Some of you may be familiar with the boycott of Qatar by a number of their neighbors starting in 2017. And when that is happening, one of the problems that Qatar faced is that a media company called beIN Sports, which is Qatari, faced an egregious violation of their intellectual property rights in Saudi Arabia. A pirate entity called BOutQ was set up, and that pirate entity started taking media content belonging to beIN, including the FIFA World Cup matches and very high-profile sporting events, and broadcasting it under their own name. And they were selling subscriptions on the open market. They were advertising, and this was all done quite brazenly. Now, in that case, when Qatar brought a case against Saudi Arabia invoked Article 73 of the TRIPS agreement, which is virtually identical to Article 21 of the GATT, and said this is essential security interests, and we invoked the defense. Now, that panel, again, followed very much the same steps as the Russia Traffic in Transit panel, found that there was an emergency in international relations. And the reason the panel found that, part of that was there was a severance of diplomatic relations by Saudi Arabia and number of neighbors against Qatar. And that to the panel showed that there was serious tension between the states, and that meant there was an emergency in international relations. But when it came to the chapeau, considers necessary to protect essential security interests, the panel said that a part of Saudi Arabia's violations of the TRIPS agreement could not be justified. That is Saudi Arabia's failure to initiate criminal procedures against the willful commercial scale piracy, which violates TRIPS provisions. That conduct, the panel could not see, and Saudi Arabia had not explained why that was necessary for the protection of its essential security interests. So on that basis, the panel found that particular violation was not justified by Article 73. And that became the first instance where a complainant in a WTO dispute managed to prevail over the respondent's invocation of the security exception. Now, there are a number of other cases pending before WTO panels where the security exception has been invoked. We will probably see decisions in those cases in the next few months. And some of them may add to this jurisprudence or clarify other matters, all of which are interesting decisions to look forward to. Now, what are the lessons that you can take away as a WTO litigant from these disputes which have come out so far? One is that security exception is not an unbeatable defense. So unlike the old days, if you're the complainant and if you expect the respondent to invoke the security exception, that in itself is no reason for you to not bring a dispute or think of abandoning the dispute. It is not an unbeatable defense. Second, it is still a very difficult defense to beat, because the respondent still has quite a bit of discretion when it comes to whether or not it considered something necessary for the protection of its essential security interests. There is still a large degree of deference. So this is still a difficult defense to beat. And a third is when you're talking about an emergency in international relations, there is often a tendency among states to talk about why a situation came to be. And if you're talking about something like an exchange of force or a severance in diplomatic relations, there is often a tendency for states to say that the other member caused this particular situation. And I have sympathy for that effort because it's a fundamental rule of international law that no state should benefit from its own wrongdoing. So if a state, through its wrongdoing, brought about a particular situation, that state should not benefit from that situation, which is a product of its own wrongdoing, and that should not be the basis on which an exception is sustained. But that effort to talk about why a circumstance came to be has not been successful in WTO disputes in the context of the security exception. In both Russia traffic in transit and in Saudi Arabia protection of IPRs, the panels said all that matters objectively, there is an emergency in international relations. The panels were not going to look at whose fault that was or how that situation came to be. So the utility of that kind of a narrative, at least for the purposes of beating an Article 73 defense, needs to be rethought. Of course, there may be reasons why members want to raise that kind of argument to put their positions on the record and to create a narrative, create a track record of having said certain things and having protested certain positions. But in terms of purely defeating an invocation of Article 21 of the GATT or Article 73 of the TRIPS agreement, the why of an emergency does not seem to matter a lot. So I'll leave you with that.